Good evening.
Is this for us?
Well, we're delighted to see so many of you here this evening, and we will quickly get started. It's my pleasure to welcome all of you to the Vanderbilt campus because I know some of you all are not associated with the university community, but we're so happy to have you here. And I believe that this panel will be very engaging as well as informative. Many of us are here because we're concerned about the growing threats to religious liberty in America, and we believe that the way to combat or to understand what we're seeing is to begin to talk about it, to engage in dialogue, and to try to understand what's happening and also some of the ways that we can unite as a group and as a community and as people who love America to begin to address these changes. And they are changes when it comes to religious liberty. And what we see is especially troubling in a nation where about 78% of the people profess to be believers in the Judeo-Christian God. And even more people, more than the 78%, profess to be God-fearing. Yet in America, we have reached a point where we find that our institutions, public and private, our governmental institutions, as well as colleges and universities, have begun to put in place policies, programs, and regulations that seem to threaten values and principles that we hold dear. Our Constitution protects religious liberty as well as the International Covenant on Civil and Political Rights, Article 18, which guarantees the right to freedom of thought, freedom of conscience, and freedom of religion. According to Article 18, freedom of religion includes the right to practice, to observe, to worship in accordance to one's religious practice. Under the Article 18, if you look at the United States today and some of the policies that seem to be emanating from the Obama administration, some of the policies that we see on university campuses, we kind of wonder if they're not in violation of this international standard of human rights. The State Department uses these to determine whether or not countries are respecting the human right of religious freedom. And some of the violations and prohibitions include arbitrary prohibitions or restrictions of or punishment, first for assembling for religious practices such as worship, preaching, and prayer, and also arbitrary registration standards. And under these guidelines, a country that would impose upon religious people regulations and policies that causes them to act contrary to those deeply held religious beliefs would be held suspect. They would be seen as a country that was violating a person's religious freedom. And so it's not just the protections that we have under the First Amendment of the Constitution, it's also the fact that under international standards, there is a belief and that we will respect freedom of worship as a human right. Tonight, our three distinguished guests will discuss freedom of conscience, freedom of speech, and also the Prohibition 8, the California's restriction on gay marriage that was recently declared unconstitutional by the California Supreme Court. And so that's one of the issues that will be discussed. And the way I've set up the panel, each of our speakers will spend about 15 minutes on their topic. 15 to 20 minutes on their topic. Each of the speakers will speak, and then afterwards, we will open the floor up to questions. And we'll begin with Professor Michael Paulsen of St. Thomas School of Law. And he will start the discussion with an analysis of religious freedom, in particular looking at the university campuses and Vanderbilt University. We'll next hear from Professor Robert George of Princeton University. He will discuss California's Proposition 8 and the growing trend towards state approvals of gay marriages. And lastly, we'll have Professor Blumstein, who will address the constitutionality of Obamacare and the battle between the administration and the Catholic Church. And we've passed around the long form of our speakers' bios. And you can see that I'd be here 15 minutes longer talking if I had to read all of those accomplishments of our speakers. Professor Paulsen is professor, as I've said, he's professor of law at St. Thomas School of Law. He's one of the nation's leading scholars of constitutional interpretation. He's an expert on the First Amendment and on issues that relate to the free exercise and the establishment clauses of the Constitution. He's a former counsel for the Center for Law and Religious Freedom in Washington, D.C. Professor Robert P. George is a former colleague of mine and a friend, and he is director of the James Madison Program in American Ideals and Institutions at Princeton. He is the author of many books, including The Clash of Orthodoxies, and is co-author of Embryo, A Defense of Human Life. He's also one of the 3 drafters of the Manhattan Declaration, which is a call to Christian conscience, which offers a bold defense of marriage, the family, and religious liberty. And the Manhattan Declaration was signed and presented on November 20th, 2009, and it presently has over 500,000 signatures. And this Manhattan Declaration is something that if you really care about traditional values and principles, you're concerned about the family, you can show your support by going to that website and signing that declaration. And lastly, my colleague, Professor Jim Blumstein, is one of the nation's most prominent scholars of health law, law and medicine, and voting rights. And he's one of the university's 13 distinguished professors, and he's tenured in the law school as well as the medical school. Professor Blumstein has argued on the winning side of several U.S. Supreme Court cases, and he has a few cases with his name on them. And so that's a big deal. So this is a very distinguished panel. And I could not have afforded to bring these people here. They have come because they care about religious freedom, they care about America, and they're here, to share their ideas with you all and to allow you to pick their brains about these issues. And so we really are honored to have them here tonight. And there are a number of sponsors that I'd like to thank. First of all, Lee and Kelly Beeman of Beeman Auto, and they're not here tonight, but their generous contribution helped make this possible, as well as the Intercollegiate Studies Institute. They do have a representative here somewhere, and they were very helpful. They were very helpful with organizing the event and contributing towards the financial costs. We also would like to thank Vanderbilt University's Law and Government program, as well as the staff. A number of people worked very hard to make this successful. We owe a thanks to the Campus Republicans. They made a financial contribution. And other sponsors include the Christian Legal Society and Young Americans for Liberty. So let's give them some applause. The Intercollegiate Studies Institute is particularly significant because across the country, they work with colleges and universities in sponsoring events like this one. They also contribute money for internships, scholarships. They publish books. They're very much involved in teaching, identifying, and training the next generation of young leaders. And they have a deep commitment to free market ideas. They believe in the American founding and the contributions of Western civilization, that these should be something that you acknowledge, you don't try to run away from. The ISI representative has a table here, and there's some information about how you sign up for membership, and there's a card, cards that you can fill out, pass to the end of your aisle. They will be picked up, and at the end of the meeting, we will announce the winner of a book. There will be a raffle, and someone will win either my book or Professor George's book, but there will be a gift for filling out the form.
The winner will win your book. The loser gets it.
And so with that information, I would turn the podium over to Professor Paulsen. Thank you.
Thank you, Carol, and it is truly a pleasure and an honor to be here. I want to thank Carol Swain for setting up this wonderful event. I want to thank Vanderbilt University. I want to congratulate Vanderbilt University, not on its religious freedom policies, but on beating Harvard, yes? Now, my friend Robbie, I think, Harvard Law School? Yeah. Yeah.
What can you do?
Yale Law School. You know, we've always thought Harvard is sort of Darth Vader spelled sideways or something like that. Well, my assigned task has been to talk about freedom of speech, freedom of association, freedom of religion on college campuses, and the vehicle that I've chosen to do it is to talk about things going on at Vanderbilt, all right? And I've passed out this handout, most of you have, except the latecomers. The professor can't talk without some sort of teaching and mechanism. And I've given this the kind of overly provocative title, Vanderbilt's Constitutional Right to Despise Christianity. So I will actually be defending both sides of that. I'm going to end up defending Vanderbilt's legal right to engage in conduct that I think is incredibly stupid and discriminatory and is really actually hostile to religion. So it's sort of, you know, those sort of things in tension. I was talking to my 13-year-old daughter. 13-year-olds, you know, they're kind of wonderfully half-respectful for what you do. You know, she was saying, well, so what are you doing at Vanderbilt? And I said, well, we're going to be talking about religious freedom. You know, there's a reason why, because there's a controversy going on that's been going on at Vanderbilt that we've been following from afar. And she said, well, what's that? And I said, well, and I had to take a deep breath and try to put it accurately. I said, well, Vanderbilt University has adopted a policy that says Christian student groups can't require that their leaders be Christian. And she guffawed. She laughed. She said, come on, really? And I said, no. I said, no. Their policy is that a Christian student group and other religious groups can't require that its leaders or members agree with or share the purposes of the organization. She said, no, you're making that up. And so I read to her from the email originally of Gretchen Person, who held the title of Director of Religious Life, that in response to the Christian Legal Society chapter's application of its constitution for recognition as a student group, you know, they said we would want that our members, and well, especially our leaders, accept Jesus Christ as Lord. It's a Christian organization. And they should be willing to lead the members in worship, prayer, and Bible study, and they should try to exemplify Christ-like qualities. And they were told in an official notification, Vanderbilt does not allow religious groups to have such qualifications for religious membership. And just this past week, Vanderbilt declared the official policy that says it will exclude from campus recognition student groups that impose faith, I'm quoting now, impose faith-based or belief-based requirements for membership or leadership. Now, I didn't bore my 13-year-old by reading to her the precise language, you know, but she said, you know, well, if that's the policy, what's the point of having a group? What's the point? What's the purpose? It's ludicrous. And I said, well, from Vanderbilt's perspective, you know, they want to keep student groups from being discriminatory. She says, they're discriminating on the basis of belief, on the basis of what they believe in. That's what you have a club for, is, you know, for groups to form around commonly held beliefs. But then I added this wrinkle. I said, okay, I tend to agree with you, but it's a private university. Does that make a difference? She goes to a private religious school. I said, would you want some outside organization or the government to come and tell your private Christian religious school what groups it could or could not refuse to allow to meet, what employment policies it would have? And she grasped readily, she's a smart kid, she's my daughter, that there's a distinction between a private institution and a public institution. So as much as I strongly disapprove of what Vanderbilt is doing, I think its policy is not only foolish, I think in practical effect, it is a form of hostility to serious religious faith and devotion. I would still defend its legal right to do so. Now, not everything that you have a legal right to do, you should do. And in the end, I'll end up criticizing Vanderbilt's choice of policies as basically a policy of intolerance toward religion. But I will defend its legal right. So let me go to this handout. And my 3 big points, I start with first principles, talk about Vanderbilt's application of them, and then I'll go and talk a little bit about public universities and how the situation is different. But first I want to zoom out to the view from 30,000 feet and start with first principles. And this is, I think, the most important controlling principle here, is what I call the vital First Amendment right of private institutions and groups to create and maintain their own distinctive expressive identities. It is vital here that Vanderbilt is a private law school. I know there's some students here from the Christian Legal Society, but let me be lawyerly for a moment. Constitutional rights are rights that individuals and groups, private bodies, have against government. Right? They're defenses to what government power can do, but they are defenses only against government. You have no freedom of speech constitutional right as against Vanderbilt University. Rather, Vanderbilt, like it or not, agree with how they use it or not, is the one that holds the First Amendment right in this situation. I'm going to talk about the freedom of groups to define their expressive identity, just as individuals under the freedom of speech have the right to define and control the content of their own messages. You know, I get to decide what I'm going to say. Groups of individuals who band together to advance common message have the right to define and control the content of their own expressive ideas. Okay? There's a First Amendment right of groups to exercise the freedom of speech and to speak collectively and to decide what their message will be and not have that message impaired by the government, right? The Supreme Court has held more times than you can count on your fingers and toes that the freedom of a group to control its message necessarily requires the freedom of a group to control its membership, right? Because who the group is defines say and how it will be. It's part of their identity. Buttressing this basic freedom of expressive association, the freedom of a group to be who it wants to be, in the case of religious private organizations, is a freedom of religious expressive identity. Churches, private religious schools, private religious universities are protected not only by the freedom of speech, but by the free exercise of religion, too. The Supreme Court, in a recent unanimous decision, broadly embraced the right of private churches to make decisions about their own leadership and ministry. It's a case called Hosanna Tabor, just decided about a month and a half ago unanimously by the Supreme Court. Finally, I'm going to tell a short parable about this. Okay, this is a case called Berea College versus Kentucky. It's from 1908, and I occasionally teach this seminar that I call Atrocious Cases, looking for like the 10 worst Supreme Court decisions of all time. The real problem is keeping it to 10, because there's so many. But this is a case involving Berea College up the road, which is in Kentucky, which is and always has been a small private Christian college. Berea College at the turn of the 20th century believed strongly, as a matter of Christian principle, the races should be taught together. Okay? In Christ, there is no East or West, Greek or Jew, male or female, black or white. We will teach men and women, black and white, together. is still very socially activist college, I think. But this was contrary to the political correctness of the day, which held, as a matter of the best social policy, at least that's how people were thinking, that you couldn't do that. And Kentucky actually had a law that forbade even private religious colleges from teaching the races together. Went all the way up to the Supreme Court, and the Supreme Court, bless its soul, ruled for Kentucky and against Berea College. Now, I think that case should always be a lesson for those who would embrace state power to interfere with the membership and doctrinal requirements and decisions as to their own religious community of private institutions. Okay. Now, a corollary of that is for every Berea college, there is a Vanderbilt University. And the cruel corollary I have here is that if a religious college should have the right to be as religious as it wishes to be, to define its own community and its values and to stick to them and to who it hires, who it admits, how it operates, so too does Vanderbilt have the right to maintain its distinctive identity. If Berea College wants to be an intensely committed Christian school, Vanderbilt can be as intensely committed anti-religious school as it wishes to be, or someplace in between. It can define the expressive principles that it wants. And I think that freedom gives it the legal right to do a great wrong. And I think that what Vanderbilt has done is engage in a policy of religious discrimination, okay? Now, Vanderbilt has a history of this sort of thing, right? For many years, for far too many that it's comfortable for us to even say, it was a segregated institution, or at least partially segregated institution. Well into the 1960s, undergraduate schools were segregated. This was, at the time, Vanderbilt's expressive. 1960, it expelled a black, an African-American divinity school student, a seminarian, for participating in protests of segregated lunch counters in Nashville. This is James Lawson. The name is probably very familiar to many of you, okay? What Vanderbilt has done here is perhaps less pernicious, but it's kind of the same character. They've decided to define their community by excluding the expression of certain messages of which it disapproves. It has decided to exclude the possibility that its recognized campus student groups will be distinctively religious and often traditional in the moral values and ethical values that they expect for their own leaders. Now, the irony here is that Vanderbilt purports to be liberal and tolerant and embrace diversity, but they aren't liberal and tolerant and embracing of diversity when it comes to the identities of the student groups that they permit. And the irony here is that the reason why Vanderbilt may discriminate in its policies is the same principle that Vanderbilt so aggressively denies to its student organizations. And that is the right of private associations to be who they want to be and to define their own distinctive identity. Last point I want to make about that is that it doesn't have to be that way, right? The right to be wrong is also the right to be right. Okay? Vanderbilt could define its expressive association principles in a way that stood against what they want to stand against truly, that stands against their tradition or background history of racism, and that stands for embracing diversity within religious communities. Right? If you have the freedom of expressive association at Vanderbilt, you may use it to do the right things. Okay. Now I'm going to turn for a minute to freedom of speech and association at public universities, because that's a horse of a different color. Right? In fact, it's exactly the reverse rule. Okay? The first principles that operate there is that a state university is an arm of the state, and people do have the constitutional right to freedom of speech as against what the government does there. And I list there a short statement of what I think is the applicable principle, that state universities really must accept all comers in the form of student groups of widely varying views and expressive identities, and must not condition access to state facilities on those groups compromising their expressive identity. And on the back of this page, I give you, this is really small print for those of us who are over 40 or over 50. A list of the most important cases. Law students out there, there will be a test on this later on. But the key point is that government ought not to be able to exclude a private expressive organization on the basis of its expressive identity. Religious groups get to meet on state university campuses, okay? Religious groups on public university campuses have equal access rights to freedom of speech, freedom of association, in addition to free exercise of religion. Now, I have to note that there's a recent case of the Supreme Court a couple of years ago called, ironically, Christian Legal Society, different Christian Legal Society chapter at a state university law school, which I think badly perverts this principle. Legal Society versus Martinez case said that a state university, Hastings College of Law, which is part of the University of California system, could exclude a student religious group from meeting and equal access to its facilities on the basis of a neutral policy across the board that said that all student groups had to accept all comers. Now, the reasons I think that is wrong are these first principles I talked about. A private organization should hold, as against state authority, the right to define itself and its expressive identity however it wants. It was a 5-4 decision, and if I were a betting man, and I am, I'd lay money that this will be not long in being overruled, within 5 to 7 years. I think this one will have a short shelf life because it is very much inconsistent with the religious freedom cases and equal access cases. Widmar versus Vincent, Rosenberger versus University of Virginia, and it is even inconsistent with the Hosanna Tabor case from just a month and a half ago. Now, it's interesting, what Vanderbilt has done is taken the policy that the Supreme Court upheld in this Christian Legal Society case and photocopied it, right? They're mimicking what a public university would do, and they're saying, we can do this because it was upheld by the Supreme Court, or something like that. Which I put here the heading, Vanderbilt gets the wrong memo. Vanderbilt always had the constitutional right to define its expressive identity. It didn't need the Christian Legal Society decision as to a state university, and the rules that govern at a state university are not the same. Moreover, there's nothing in the Christian Legal Society Supreme Court decision that in any way prevents either a state university or a private university from recognizing student groups on their own principles. Vanderbilt can allow the Christian Legal Society and other student expressive religious organizations to have religious statements of faith. And finally, in a really perverse way, the Christian Legal Society decision as to the Hastings College of Law actually undermines Vanderbilt's position, okay? Because what that case says is that an instrument of state government can infringe upon private association rights. Okay? Let me end with another story. A friend of mine, this is not my daughter, this is a lawyer who was watching the Vanderbilt situation and calls me up and says, Mike, what can we do about this? You were always ingenious in coming up with inventive legal theories. Is there some way that somebody can sue Vanderbilt over this? And my reaction is, do we really want to? Remember, for every Vanderbilt, there's a Berea College. Whatever principles we would apply to Vanderbilt, we would apply to Belmont College, too. But in light of the Christian Legal Society case, I actually could come up with a bunch of legal theories that could be used to coerce Vanderbilt to recognize student religious organizations. It could be written into legislation as a condition on receipt of federal funds. The Tennessee legislature could pass a law, in theory, directing Vanderbilt to recognize the rights of private religious student groups to meet and define their own expressive identity. But I don't favor this because I fear it would boomerang on religious groups. No one who's really intensely committed to association can lightly embrace the idea of state authority to tell a private university, a private institution, what it can and cannot do. For better or worse, right now for worse, Vanderbilt has the right to define its expressive principles in the community it wants. But ultimately, then, the question is, how does Vanderbilt wish to define itself? What are the principles it wishes to stand for? Okay? Vanderbilt, as I understand it, sees itself as liberal and tolerant and open and embracing of diversity. But if that is truly the expressive identity that Vanderbilt wants, then it really should embrace those same principles in its policies concerning what student organizations it will recognize and permit to operate. Campus religious groups should be permitted to be who they want to be for the same reasons that Vanderbilt should be permitted to be what it wants to be. Okay? Student religious groups and other student groups should be able to define their expressive identities, and that means that Vanderbilt should respect the rights of campus Christian groups to be Christian, to create and maintain a distinctive Christian identity by having statements of faith and by expecting that their leaders of a Christian organization embrace the core beliefs, ideals, standards of conduct, lifestyle, and mission that Christians expect of a leader and disciple of Jesus Christ. Thank you very much.
Well, I want to begin by reserving the opportunity during question time to ask the first question of Professor Paulsen. And the second thing I want to say is what a pleasure it is to be speaking here with Professor Paulsen, who is a dear old friend and someone from whose writings I've learned an enormous amount, whose casebook I use in my own course in constitutional interpretation, and who honored us at Princeton this past year by coming to speak in my class. Michael is correctly identified as one of the leading authorities in constitutional interpretation, especially when it comes to religion and the Constitution, and so it's great to be here with him. And it's wonderful to be here with Jim Blumstein. I met Jim years ago when I had an offer at Vanderbilt, a wonderful chair in the law school and divinity school and Department of Political Science. One of the great attractions would have been to be Jim's colleague. In the end, I decided after much agitated thought and sleepless nights, because it was such a wonderful offer, and this is such a wonderful university, whatever little troubles it might be going through at the moment. At the end, I decided to stay at Princeton, but at the very same time, Vanderbilt had an offer out to my dear friend, Carol Swain, and Carol deserted me. And headed off to the greener pastures of Nashville, and that's really surprising because I think, unlike me, Carol is not a bluegrass banjo player, right? I am. So my visit here, when I was considering that wonderful offer, my visit here was occupied in part by some time at Gruhn's Guitar Shop. Do you know what Gruhn's Guitar Shop is? Yeah, what a place that is. Had I come here, Jim, I would have been a lousy professor. I would have spent all my time down in Gruhn's Guitar Shop. Carol, thank you for the opportunity to be here and to join in this important meeting, and congratulations on the work that you're doing in defense of religious freedom and to all the organizations and individuals who are involved in that work. Now, I am a conservative. That makes me an old-fashioned liberal. What do I mean by an old-fashioned liberal? I mean a liberal in the tradition of Madison and Tocqueville and Lincoln and John Stuart Mill and L.T. Hobhouse and Learned Hand. Hand once said, the great judge, the greatest judge never to make it to the Supreme Court, Hand once said, the spirit of liberty, and what is liberalism about if it's not about liberty? The spirit of liberty is a spirit that's not too sure that it's right. Now, does that mean that we old-fashioned liberals should be the kinds of liberals who won't even take our own side in an argument? No, that's not what Hand had in mind. What Hand had in mind was the importance to the life of the mind and to the well-being of the intellectual culture and, indeed, the welfare of society, of having a mind that was open to argument. The spirit of liberty, as Hand described it, is a spirit that recognizes that reasonable people of goodwill can and do disagree about things. That not everybody who disagrees with us, has the temerity to disagree with us, is a rogue or a scoundrel or a monster. Issues are often difficult. It's not too clear just what the right answer is. And even if we are pretty sure we know what the right answer is, and I have been known to take my side in an argument, Carol, as you know, even if we're pretty sure, it should give us pause and openness that we know that there are reasonable people of goodwill, people who are intelligent, who are well-informed, who are well-disposed, who take a different view. What does that mean? What attitude should we take toward them? Should we challenge them to duels? Should we try to marginalize them or their positions? Should we organize boycotts and protests and so forth? No. It means we should engage them because perhaps we have something to learn. And a truly flourishing intellectual community, whether it is Vanderbilt University or Princeton University or Harvard University or Oklahoma University, will be a community in which that spirit is the governing spirit, where people are open to each other's ideas and prepared to engage each other in vigorous but civil argument and are willing to learn. I'll bet you've had the experience I've had, which is you have a very good argument with a very intelligent person, and you come away unpersuaded by his view. You come away just where you were when you entered that argument, except your understanding has been enriched. You have a better sense of where the possible weak points are, better sense of why and how it is that an equally intelligent, well-informed, well-disposed person can have a different view. And you have a better appreciation of the reasons for your own position. John Stuart Mill, a founding father of liberalism, if ever there were one. In the very first chapter, the chapter on free speech, in his great work on liberty, how many of you have read Mill's On Liberty? More than a few, good. It's a classic work of old-fashioned liberalism. But in that very first chapter, Mill makes clear that his greater worry is not for the coercive power of the state bearing down on the freedom of thought of the individual. He's worried about that, but that's secondary. What's he worried about first? This is the part of On Liberty that nobody seems to notice. He's worried about the tyranny of public opinion. Now, what does he mean by the tyranny of public opinion? Exactly what we mean by political correctness. A dominant view that suffocates dissent, that creates an atmosphere in which people are afraid to express disagreement, even if they have it, and eventually come to hold back even from thinking the unthinkable, of questioning established prevailing orthodoxies. Groupthink is what Mill was concerned about. And groupthink is the mortal enemy of learning. Groupthink is the mortal enemy of everything that an academic institution is supposed to be all about. And that's why we really should care about the freedom of individuals and of groups to flourish even in their dissent on campus. That's why we need to be worried about the integrity of organizations that represent a point of view. Now, all that is on a topic that I was not assigned to talk about. But I couldn't help myself because I believe it so passionately.
Go with the spirit.
And yeah, that's right. Holy Ghost power, Sister Carol. Holy Ghost power. And it's so critical to what's going on at Vanderbilt and really around the country. What happens at Vanderbilt, how this thing is ultimately resolved, is going to make a big difference for everybody else. It can make a big positive difference if it comes out the right way. And it will make a profound negative difference. You heard it here. If it comes out the wrong way. Now, I said a moment ago that reasonable people of goodwill just disagree about stuff. And disagreeing doesn't mean that you're a rogue or a scoundrel or a rascal, much less a monster or a Nazi or a hater. And in our culture, in this great experiment, as our founding fathers called it, in ordered liberty, where we've thrown over the throne and altar conservatism of Europe and embraced that old-fashioned liberalism. Not the liberalism of Teddy Kennedy or Bill Maher, but that liberalism of Madison and Mill and Hobhouse and Tocqueville. Here, that freedom generates in our own time rather profound disagreements about fundamental issues. And so the real test comes now. What the founders called an experiment really was an experiment. Experiments, by their nature, can fail. There's no guarantee of success. Republics had not survived in earlier periods. If you look at the Federalist Papers, you'll see Hamilton and Madison and Jay struggling to defend the Constitution on the belief that we've now come up with a set of institutions which we're now proposing to the American people, a set of principles that will enable a republic to survive, free institutions to survive. But that was a time when we did not have the kind of pluralism, moral pluralism, that our freedom has made possible today. There were important structures and fractures, no doubt about it, and one of those fractures led to a civil war. There were some profound moral disagreements. You start the list with slavery. But today, we really are polarized over so many issues, fundamental issues. Does an unborn child have a right not to be killed by abortion? Or does a woman have a right to have abortions if she's pregnant and doesn't want to be? It's a profound issue. Both sides see that as a moral issue, a non-negotiable matter of moral principle, a matter of fundamental justice, a matter of human rights. But they're inconsistent, obviously. How about marriage and sexual morality generally? Is marriage the conjugal union of husband and wife? Or is marriage the romantic, sexual domestic partnership of two persons, or perhaps even more than two persons in a polyamorous relationship? Which way does it come out? Both sides think they're arguing for something profoundly important, a matter of deep moral principle, but of course they are inconsistent. Now, I've taken very strong positions on both of those issues. If you've read any of my writings, or if you're the loser in the draw and you get my book, you will see that I defend very strong positions on these things. But guess what? I defend very strong positions, but there are reasonable people of goodwill who disagree with me. And they're as smart as I am. And they're as well-informed, in some cases smarter, considerably, and well-disposed and well-informed. And they find their way to a different place. Now, how do we deal with that? We don't or shouldn't challenge each other to duels and fight it out. We shouldn't have a civil war. We shouldn't try to marginalize people on the other side. We shouldn't engage in name-calling and boycotts and all that kind of stuff. No. Our founding fathers bequeathed us a wonderful system. They called it Republican government. We've taken to calling it democracy, as a way for citizens who disagree to debate, reason together, argue with each other vigorously. Politics is tackle, not touch. I'm not trying to set up some, Shangri-La of politics where it's all the Marquis of Queensberry's rules and afternoon tea and all that stuff, much as I came to love afternoon tea when I was a graduate student at Oxford. But no, it's tackle, not touch. But at its best, and we should all struggle to make it its best, it's a game in which everyone is welcome to participate as a full and equal citizen in the debate, which we will, in the end, resolve by voting. Our democracy should be what our founders wanted it to be, what's sometimes called a deliberative democracy. It's not just, let's have a vote and let the passions of the moment win. It's let's reason together, let's argue together, and then we vote. And there are no permanent winners and no permanent losers, because the losing side can always come back and say, look, we think we should reconsider this as a society. We've come down on the wrong side of this. Listen to the argument. Listen to our argument. We'll listen to your argument. Now, in California Proposition 8, which restored, under California law, the conjugal conception of marriage after it had been displaced in a decision by the California Supreme Court, the state Supreme Court. In Proposition 8, when the issue went to the U.S. District Court, the proposition was challenged under the Equal Protection Clause and certain other provisions of the federal Constitution, Judge Vaughn Walker ruled that the proposition was unconstitutional, and that, therefore, the conjugal conception of marriage could not be restored by that proposition in California. Now, that is relevant for our deliberations here this evening because, and really only because, the judge seemed rather strongly to suggest in his opinion that among the reasons, the central reasons for the unconstitutionality of Prop 8 was that it reflected the religious opinions of the supporters of the proposition. Now that, I think, was a bad argument all the way around, and I am very confident, no matter how the case comes out in the end, that that will not be upheld. That ground for striking down the decision will not be upheld. It did not figure prominently in the decision by Judge Stephen Reinhart in a 2-1 decision for a 3-judge panel reviewing Judge Vaughn Walker's opinion for the Ninth Circuit Court of Appeals. Reinhart crafted a much, much narrower decision, in fact, one that seems to be crafted deliberately with a view to avoiding Supreme Court review. But I think on this, Reinhart's being smart both politically and constitutionally, especially in view of the prevailing precedents. I think there's no chance for the Supreme Court to essentially say that if a moral conviction has among its roots a religious basis, it cannot then be a valid, constitutionally valid foundation or basis for legislation or for public law. The Supreme Court of the United States has always veered away from that when it's been proposed to them, and I don't think they'll accept it again, and they're right not to accept it. The effect would be to disenfranchise religious people. You'd have a heck of a time explaining, for example, why Martin Luther King, in his very religiously based appeals against segregation, wasn't doing something contrary to at least the spirit, if not the letter of the Constitution, or whether legislation, civil rights legislation, that was reflective of views like Dr. King's views would not be unconstitutional as a result. So I think it's very important, no matter how the case comes out, that the reasoning not embrace that idea that religiously motivated actions by citizens or legislators are in principle unconstitutional, and I don't think they will. There's a fancy political theoretical justification for trying to limit religious reasons as bases for legislation or other political action. I won't go into it here. Those of you who've studied a bit of political philosophy will recognize it as the work of John Rawls, the late and very great Harvard political philosopher, who developed a theory of justice, which included a theory about the sorts of reasons that could be considered legitimate for political action when it comes to constitutional essentials and basic justice, a theory called the theory of public reasons. And under Rawls's theory of public reason could be understood as restrictive enough that it would rule out some citizens, some religious citizens, as really full participants in public affairs. I think most people wouldn't want to go that far, even those who are leaning toward the left side of the spectrum. But something like that, I think, was what was in the spirit of Judge Von Walker's decision. Now, on the other side of the equation is this. I think that it does fall upon religious people of all faiths, when entering the public square, to make their arguments, even if they are religiously inspired arguments, to translate the language of religion into a language that is accessible across theological boundaries and even to those who do not consider themselves to be people of faith. What in the broad tradition of Western thought, what Sir Isaiah Berlin called the central tradition of Western thought, is sometimes called natural law thinking. For Christians and Jews, I suspect the same is true for Muslims, although I don't know their tradition quite as well. For Christians and Jews, the mainstream of those traditions holds that God did not act arbitrarily even in his commands, that there are reasons having to do with God's willing of the integral good for man and for the community. There are reasons for the moral norms by which we should govern ourselves. And the articulation of those reasons, I think, represents a valid concept of public reason, one that is not as cramped as Rawls's, but which serves the overall common good by bringing citizens into dialogue with each other, into true democratic dialogue, despite the fact that some are Methodists and some are Baptists, some are Jews and some are Christians, some are Muslims and some are Buddhists. The articulation of reasons in the language that transcends those borders helps the democratic process to be more fully democratic because you have real, genuine engagement. Now, that doesn't mean checking your religion at the door or reducing your religion to a merely private status. One thing that's to be absolutely avoided, in my view, is the idea that religion belongs in the house of worship or in the home around the dinner table or on your knees in front of your bed at night, but doesn't belong out in the public square. That would be really contrary to the American tradition. I mean, the abolitionists did not leave their religion in the house of worship. Dr. Martin Luther King, Dr. Ralph Abernathy, those who joined with them, Abraham Joshua Heschel, the great rabbi, Richard John Newhouse, then a Lutheran priest, later a Catholic priest, they were people who brought their faith into the public square. So the privatization of religion is not what the goal should be. You've probably heard, this story of, the politician who was so firmly convinced, who believed so strongly that religion was a purely private matter that he wouldn't impose his own religion even on himself. Sometimes we go off the deep end with this idea of privatization, and while religion certainly has its private dimensions, it also has its public dimensions, no matter whether we're talking about Judaism or Christianity or Islam. There's a public role for religion. But it shouldn't be a role that ends up having the effect of meaning Christians can only speak to Christians, or Baptists only to Baptists, or Southern Baptists only to Southern Baptists, or Free Will Baptists only to Free Will Baptists. We need a language the language of civic life that enables people to communicate with each other across those boundaries. By all means, people should still be free and should be robust in making appeals to their own traditions, which are, after all, in many ways, wisdom traditions. I learn a lot from people who I'm a Catholic. I learn a lot from my friends who are evangelical Protestants, who are Jews, who are Muslims, from their traditions. These are traditions that have been around a long time. They've got a lot of experience. There's stuff any Christian can learn from Talmudic teaching. There is stuff that any Jew, I think, can learn from the New Testament idea. You don't have to believe it as scripture to glean from it the wisdom that is there. So I think we should be able to share with each other our religious language, but we should also be able to talk with each other in a common language. Thank you.
And there's a great old story about Senator Lyndon Johnson when he was running for Senate in Texas. He was in a rural part of Texas, and he was on a platform, and he was introduced to a school teacher who was there with him. And so he said, "Well, young man, what do you teach?" He said, "Well, I teach geography." And he says, young man, how do you teach it these days? The world is flat or the world is round?" And this teacher just didn't know what to make of Senator Johnson's or Mr. Johnson's question. So he looked at him, he says, "Well, tell you the truth, Senator," I said, "I can teach it either way." And so it is important that there are limits on this, but I do want to identify, and I'm going to talk about that in a minute. My task is to talk about the issues of religion as they relate to health care, and I'm going to talk about the Affordable Care Act and the contraception debate as the culmination of this, but I want to start off by, just as an introduction, discussing the concern about insensitivity, the one that my two colleagues have talked about before, the insensitivity to religious-based preferences, and in some cases, and I'm going to tell a story to start with, about a pharmacy case out of the state of Washington, a federal court case, about hostility to deference to these religious-based preferences. And I think that this is really a concern and a problem. Then I'm going to talk about the constitutional and statutory structure that govern these issues. I'll talk about the Affordable Care Act and its application to religious employers regarding contraception. And then I'm going to apply some constitutional principles and ultimately statutory principles on the Religious Freedom Restoration Act, or RFRA legislation. So that's the outline of what I'm going to talk about. Both Robbie George and Michael Paulsen have talked about the importance of civility and discourse, and it starts from mutual respect. It is humility. As I've gotten older, I came to Vanderbilt as by far the youngest faculty member, and I'm now the senior most faculty member here. Over the years, I guess I have come to be very different. And when I came, I thought I knew a lot, and now I really am awed by how little I know. And so there's a certain humility that you get with experience and age, and I think that humility is an important first step in having the kind of discourse that both Professor Paulsen and Professor George have described. It's a sense, as Professor George says, not that one is reluctant to advocate, but also to recognize that pancake, as flat as it is, has two sides, and that there are other perspectives that are brought to the table that have to be dealt with. And so, again, there's always a risk. My father liked to tell the story of this couple that was married for 50 years, and in their 50th anniversary, they threw themselves a big party, and they decided that some friends and family wanted to know what was the secret of their success, and so they had a little Q&A, and a man asked the husband a question. So, isn't it true for a successful marriage that the man has to be the head of the household? He has to rule the roost. He said, you have a good point. a woman raises her hand and says, well, isn't it true to have a successful marriage, you really need to have an equality, a sharing of experience, and a 50-50 partnership? And he says, you know, you've got a good point, too. And a third person, a man, raised his hand and said, well, isn't your answer to the first question inconsistent with your answer to the second question? He says, you know something? You've got a good point, too. So let me say a little bit about this. I think there's a concern about a growing insensitivity or even an intolerance of religiously based preferences. I think there's a sentiment in some quarters that religious preferences are really a cover or a cover-up for bigotry or for objections and rejections of fundamental interests, and where religious-based views, even if sincerely held, are seen as obstacles for the achievement of very passionately pursued objectives. And I think this creates a certain poison within our public sphere. I think it's analogous, as I was thinking about this in preparation for this program, analogous to criticisms that we've often seen of federalism, a value that I've come to appreciate and think is extremely important in mediating conflict. But federalism, in many quarters, has a bad name because it was seen as a cover for race discrimination and at one time slavery. And so those values are being resurrected modestly, I would say. But issues such as gay marriage that Professor George was talking about, where he was critical of a Supreme Court constitutional decision that would have a uniform constitutional rule and would strip from the democratic process the ability to make these determinations on a jurisdiction-by-jurisdiction or state-by-state basis. Well, I think he's making the claim for federalism there, that this is a matter that has to be or should be argued out in the political arena in 50 different states and 50 different jurisdictions, not ruled uniformly. And so federalism for advocates of gay marriage has gotten a little bit of a better reputation because these issues don't have to be one size fits all. They can be argued and discussed different for Massachusetts than for some other states. I think also we've seen more generous social welfare programs. We've seen stronger environmental regulations like California's emission standards and mileage standards and so forth, suggesting that a one-size-fits-all approach is not necessarily the best answer. And part of the genius of the nation is that we have different jurisdictions in which we can argue and different constituencies. I've argued in a piece I did almost 20 years ago, hard to imagine, that federalism values have much in kinship with civil rights values. They're geographically based, but that they're designed to allow different majorities in different parts of the country, geographically based majorities, to have their will without having to negotiate or being subject to national majorities. Religious exemptions have historically been more favored when associated with causes that opponents would actually embrace, such as conscientious objection to military service. And yet we've seen an emergence, and Professor Paulsen mentioned the Hosanna Tabor case, which just recently said that a ministry exemption to the enforcement of civil rights laws, employment laws, is constitutionally based in the First Amendment. So we're seeing a bit of a resurrection of recognition of the significance of religious exercise and how that empowers people within their own sphere to make important decisions that are critical to their own being and their own sense of self. I want to report an example of hostility in the medical arena, though, that was so stunning to me that I thought I would just report it. It's been underreported. It's a recent case decided by a district judge in Seattle, Washington, federal district judge, a case called Stormans, Inc. versus Selecki, and it involved a religious conscience provision for pharmacists with respect to the so-called Plan B drug, which is the day-after pill, with respect to abortion. 42 states, and until 7 years ago, Washington State had a conscience provision where pharmacies and pharmacists were not obliged to prescribe this day-after pill if it violated their faith tradition. Folks who tend to be called pro-life in our constituency, in our community, many believe that this is a form of abortion, or it's in a technical term, abortifacient, and resisted providing or filling prescriptions for these drugs, or didn't want to carry them in their pharmacists. In 1995, Washington adopted a law that respected this faith tradition and did not require any pharmacy or pharmacist to actually fulfill a prescription for this type of pill. That is to say, there was a duty to accommodate on the part of payors and others in the healthcare system, pharmacists who declined to provide a medical service based on his or her conscience. Now, in 2005, this changed in Washington. The first state, according to the opinion of the court, that changed this was Illinois under Governor Blagojevich, who at that time was wearing a different kind of pinstripe suit. Governor Blagojevich signed an emergency rule that required pharmacists to dispense emergency contraceptives such as the day after pill if the pharmacy that he or she was associated with stocked any form of contraceptives. 8 states, including Washington, now limit these conscience-based referrals to some extent. 42 states respect this type of conscience-based decision, in which case the pharmacist will refer and is expected to refer the patient to a pharmacy where the patient can obtain the contraceptive or the day after pill. And this is a case where I don't have to say his or her, because this is a case where it is a her, it's a she, who would seek out this pill. Now, in 2005, Planned Parenthood and the Northwest Women's Law Center, joined by the National Association, National Abortion Rights Association, NARAL, sought to prohibit this protection for conscientious referrals for Plan B. The message that was being communicated by Planned Parenthood, and I'll just say Planned Parenthood, but by the advocates, was that pharmacists who had a conscientious objection to Plan B should, quote, find another line of work. And this came from an editorial. The advocates, and this comes from a person in state government who was accepting the advocate's position and had been influenced by Governor Gregoire to get on board with this agenda, where he said in an email, the moral issue is, underlined, the basis of concern. In other words, one morality was going to trump another morality. That is to say, it was important from their point of view to protect the public from, quote, unwanted intervention based on the moral beliefs of a pharmacist, end quote. Now, this is pretty striking to me. I was not aware of the case. I'd read a small newspaper story about it, and there's about 60 or 70 pages of opinions on this issue. But the goal was that there be no recognition of conscientious objection. That was the goal, because the moral objection was unwanted and objectionable by the persons who were seeking Plan B. The advocates said, despite what the good faith, sincere beliefs of the conscientious objectors were, that Plan B was not an abortifacient. And their goal was, and I'm paraphrasing, but it's almost a quote, to prosecute all the conscientious objectors who refused to fill prescriptions. Put them in jail. Now, the evidence at the trial, one might think that access was the problem. And when I told the story to a friend and colleague, he said, oh yeah, wasn't there a problem of access to Plan B in Washington? Well, the evidence, the findings of the district judge in this case, quote, revealed no problem of access to Plan B, end quote, either in urban areas like Seattle or in rural areas of Washington. Not a single drug in Washington was identified at trial where there was an access problem. There were anecdotal stories that were paraded before the judge, and he went through them methodically and rejected the claims as a matter of fact. And it turned out in Washington, Catholic hospitals and their pharmacies were not prosecuted, even though it was known to the officials that the Catholic hospitals and their pharmacies were not either carrying or, in some cases, carrying but not dispensing, except in cases of rape or, rape. Were not dispensing Plan B. They were not prosecuted. They were the good religious objectors. They went after other religious objectors. I commend it to you. This is Stormins, Inc. versus Selecki. The detailed findings are just striking. And after 42 years of teaching, I am not blown away by factual findings very often. But I just wanted to share this with you because this, to me, is an example of the problem of intolerance. That this is an example of one group of advocates seeking not just to deny conscientious objector status, but to put them in jail because those values are at odds with the values of the advocates. This is not tolerance, it's intolerance, and this is a problem. Now, I'm not saying that the Affordable Care Act and the Obama administration implementation of the contraception provisions reflect the same degree of animus. I don't think there's evidence for that. But we don't have an evidentiary standard yet. We don't have a trial. We don't know what's going on. There is litigation, and we will see what's going on, I'm sure. Now I want to turn more lawyerly to the constitutional and statutory structure in which this issue will be discussed, and I want to talk about the actual issue. The constitutional provision is the First Amendment. The First Amendment is one of those interesting provisions with respect to religion because there's a ban on the establishment of religion, and yet at the same time there's special protection for the free exercise of religion. And the two are obviously in tension. If you protect free exercise too much, you may run into a problem of establishing religion. We know, and historically over the last couple decades, that the Supreme Court has been more sensitive and sympathetic to the freedom and the ability of government to accommodate the free exercise of religion without running afoul of the Establishment Clause. And this is the accommodationist idea. If there's been a trend in the religion cases recently over the last 20 years, it's been the court's willingness to allow government to accommodate free exercise of religion. And building upon what Professor Paulsen and Professor George were talking about, and an excellent op-ed article, by the way, in the Tennessee, and let me give a shout out to Justin Gunner, who wrote an excellent editorial along these lines, is that this issue for me is really an issue of self-restraint and accommodation, and should not be, although I'm going to talk about the law, it should not be something that the law commands. This should be something, a matter of persuasion. It should be a matter of deference and mutual respect. Now, I meant the Hosanna Tabor case that's been mentioned did create an exemption to the civil rights employment discrimination laws that was derived from the Constitution, and so free exercise values have been given a constitutional boost in that very recent unanimous decision. The statutory provision that I want to talk about is the Religious Freedom Restoration Act, or RFRA. It says that there shall be no federal intrusion on religious exercise unless there's a compelling interest, and that the compelling interest is served in the least destructive way, or the least drastic alternative. The general doctrine on religion and free exercise comes in a decision by Justice Scalia from 1990, the Employment Division against Smith case. And the general rule in religious exercise cases is that there's no right of religious freedom to a special exemption for religious conduct as opposed to religious belief when the government can regulate the conduct and does regulate it by neutral and generally applicable laws. That is to say, if the government bans the use of peyote or narcotics as a general matter, the fact that a particular religious sect uses peyote in its religious ceremony does not insulate it from illegal conduct. But there can be no governmental restriction on religious beliefs, such as prayer, or on religious acts, such as the act of prayer itself. And there cannot be any targeting of religious conduct. Neutrality is the critical variable. No targeting is the objective. And so the example is, for instance, there was a case where a police department banned police officers from having beards, but provided special exemption for persons who had skin problems. So your beard could cover up your skin blemish. And this case was brought by a Muslim officer who said it was his religious faith that he had to be able to wear a beard. That was part of his religious exercise. And the court said you accepted a secular reason for having a beard, you also have to accept a religious reason. You can't devalue the religious reason and accept the secular reason. Now, government can, even if it doesn't have to, make accommodation for religiously based decisions. And government cannot prefer secular to religious-based exemptions. So that's the general doctrine in broad brush. What does the Affordable Care Act do in this regard? The structure of the Affordable Care Act is that there's an emphasis on preventive services without co-payments or cost sharing or deductibles. That's the goal. That's the holy grail, one of the holy grails that was pursued by the Affordable Care Act. Preventive services without cost sharing. No financial barriers to access. The goal is to encourage the use of preventive services. It was deemed to be important and cost effective. Then the issue became what preventive services to cover. And the government farmed this out to an institution called the Institute of Medicine, which is part of the National Academy of Sciences. And I actually am a member of this august body. They were asked to analyze what were critical or core preventive services. And they came back with a report that included contraception. And instantly, almost, the government accepted the requirement that contraception fall within this category of preventive services. And so the regulation that was proposed in August of 2011 includes contraception as a covered preventive service without cost sharing. And that's the critical point, that it's not only contraception, but contraception without cost sharing. And this is mandated for all plans other than those who have a special status as grandfathered plans. The regulation contemplates an exemption for religious organizations for certain religious employers, but it defines a religious employer very narrowly as follows. It's an organization where the inculcation of religious values is its purpose, and it's designed to be focused on churches as opposed to church-run hospitals, charities, or schools. So the inculcation of religious values is its purpose. It primarily employs persons who share its religious tenets. It primarily serves persons who share its religious tenets, and it's a nonprofit organization such as a church. So you can see that the goal is to limit the exemption to churches and institutions that have religion as their primary mission, not just that are run by churches such as hospitals, charities, or schools. Now, the government included a temporary safe harbor from enforcement, basically saying it's illegal, but we won't nab you for a year. And you have a year, which just happens to coincide after the election of next fall, that there will not be enforcement. And originally, that was it. No enforcement, and that was the end of it. But a furor emerged, and therefore the final regulation that was adopted contemplated some consideration of alternatives. Now, we know that the president announced that the alternative would be that the insurance companies would be obliged to provide these services, but the church would not be obliged to pay for it. Well, this is an interesting tooth fairy exercise, and I have been puzzled about how this would work, and so I actually did some research to find out how the language was drafted and captured. Well, guess what? That language does not exist. The regulation that was implemented is the old regulation that the president swore would not be implemented, but it was adopted in haec verba. In other words, in the exact same words that were proposed in August of 2011, with the following aspirational, or shall we say precatory language, that we will have a new rulemaking. Those of you know administrative law means you have to start over from scratch, start with notice and comment and so forth. There will be a new rulemaking in which we will sit down with the stakeholders, and we will be influenced by the states that have dealt with this in the past, such as Hawaii. And they gave a sentence to explain about what Hawaii does. And there are serious problems about linking up the authority of the federal government with the power that the Hawaii insurance regulator has on this deal, because it's not clear under the Affordable Care Act that the president or the HHS has authority to tell the insurance companies what to do. This is far from clear. So I was looking to see how they had pulled that hat out of the rabbit out of the hat, how they had become Houdini, and in fact, it's to be determined. And so we don't really know how this is going to happen, but we're told that it might happen, and of course, all the media seem to think that it actually has happened. But when you actually look at it, nothing has happened, except to say that we will sit down with the stakeholders within a year, and we will work this out. We'll be influenced by Hawaii. This is what Hawaii does, and we think we may be able to find a way out. But there's nothing there, and all there is a press statement. And so this was going to be the way to solve this problem. And there's an interesting statement for those of us who like to dig down into the law, that it says, free exercise is not violated and RFRA is not violated. QED. That's it. That's all there is. There's not anything more. And so, you know, tomorrow Eric Holder will be here, the Attorney General, speaking at Vanderbilt, and some active student might want to say, well, how do you prove this? How do you establish that RFRA is not violated? So now I want to talk in the 5 minutes or so that are left to me about the constitutional application and about the RFRA application. I think that our discourse is such that people want to say this is unconstitutional. Now, it may be unconstitutional, but on its face, I think it's probably not unconstitutional. Because on its face, it looks like this is a law of general application and it's neutrally applied. There are no secular exemptions. This is not like the so-called Lukumi case, where animal slaughter seemed to be barred across the board, but there are lots of secular exemptions. There was not a religious exemption. Here, there are no exemptions, except a small religious exemption. And a non-broad religious exemption does not mean that religion is being discriminated against. It's getting preferential treatment, but not as much preferential treatment as one might hope. And so, so I think that there's a problem with a constitutional challenge on this ground. But as Professor Paulsen knows, this afternoon I had an aha experience. There may be some light at the end of that particular tunnel, because one of the justifications that advocates, and sometimes overly zealous advocates, should talk to their lawyers before being advocates. And an overly zealous advocate said, including the Assistant Secretary for Planning and Evaluation, that the contraception provision will be cost neutral, or maybe even cost saving. And then you begin to scratch your head. If this is cost neutral or cost saving, why would a profit-oriented employer not do this on its own? Why do you need a mandate to achieve something that's in the employer's own self-interest? And then a little aha experience is, well, maybe there are some employers that are not profit-driven, that they may be religiously driven, and that even though it may be profitable to have such a provision for contraception without cost to the employees, it may be that we don't care if we're the church, that it violates our religious values, and we're not going to include it even if it's economically viable. And then you begin to say, well, maybe this is actually targeting. Why else would you have it unless you're targeting a religiously oriented institution? And so if it's targeting, then my kind of litigation hat comes on and says, well, there's a shot here. That may actually be a theory that would be worth trying out. But I think the stronger argument is the statutory one, the RFRA argument. And the Religious Freedom and Restoration Act says that, that there must be a compelling, if there's a substantial burden, let me get this right, if there's a substantial burden on religious exercise, it can only be justified if it meets what we call strict scrutiny, that there's a compelling interest and that there's a very narrowly tailored relationship between the means and the ends. The problem is the regulation has zero analysis. So challenges under RFRA have already been filed against the original rule. Because of the temporary enforcement, there's an argument that it's premature, but the rule does exist. The case is Belmont Abbey College versus Sibelius. There are others as well, but that's the one that I think is the lead one. And there's a RFRA challenge. The argument is that there's a substantial burden on religious exercise of a Catholic university or Catholic college, by implication by Catholic hospitals and Catholic charities as well, and that this is a substantial burden on that religious exercise, and ultimately is having this available when there's relatively modest cost associated with the purchase of the service, because there's no prohibition on the purchase of the service, or are there reasonable alternatives that would protect the religious institutions from having to pay themselves, like through public funding or so forth. I think that if the threshold of substantial burden on free exercise is satisfied, it's very unlikely that the court would find that the strict scrutiny standard is satisfied. But let me conclude where I started. As a lawyer, it was a challenge to think of a constitutional claim here. Everyone wants to talk about the Constitution. And I think now that the provision I described may be subject to constitutional challenge. The discourse is constitutional. I think that's wrong. The discourse should be respect and mutual respect. And if statutory, that's better, it can be changed. But we should be advocating for mutual respect and not for demonizing institutions that have honest, good faith, sincere, religious-based beliefs that are trampled on in these circumstances. This is an important value. It's a value that we should respect, and we should not try to polarize it, politicize it, but we should live with it. And here, everything's part of a balance. The consequence of non-adherence is a maintenance of the status quo. It just means that the dream of preventive services, including contraceptive services, without cost sharing, will have to be deferred for certain employees. And I think that's a fairly small price to pay for the maintenance of religious liberty. But it shouldn't be constitutionalized. We should be able to persuade folks to that effect, and the political process is where that persuasion can and should occur. Thank you very much.
We're going to take about 10 minutes of questions, and there's a microphone over there that you can use, and I believe there's a freestanding mic somewhere.
Oh, with only 10 minutes, I'll ask Michael privately. I was going to throw him a big hanging curveball.
No, we want to hear your question.
We'll see if I can hit a curve.
Ready?
Yeah.
Here's the curve. I'll bet, don't know for sure, you tell me, that all over its literature, Vanderbilt University proclaims itself to be an institution that values academic freedom, the free expression of ideas, basic freedoms, freedom of association, and so forth and so on. Now, Mike, you might recall when you and I were toddlers, and before I was at Princeton University and before you were at St. Thomas, Princeton was the subject of a famous piece of litigation. It was called the Schmidt decision. Yeah, you remember it, Jim. And in Schmidt, Princeton University, a private university, was sued by the ACLU. Sanford Levinson, who was then an assistant professor without tenure at Princeton, represented the complainants that were, it was a racist, some kind of a racist outfit, distributing racist literature on the Princeton campus. Now, as a private institution, Princeton was absolutely sure that it had the right to exclude anybody it wanted. The argument was exactly the argument you were making here for Vanderbilt's legal right to do something bad. Princeton lost, despite its confidence that it had a knockdown victory because it was a private institution. It lost, my recollection is 6-0 in the Supreme Court of New Jersey. And then 8-0, there was one justice who recused himself in the Supreme Court of the United States.
It was affirmed?
Yeah, it was affirmed.
Actually decided?
Yes, it was decided. Well, there was it was a cert denial.
Oh,
It was
okay.
not,
Yeah.
yeah, the court didn't
And-
decide that
And
case.
the argument that prevailed was that, sure, if Princeton wanted to declare itself to be a narrow-minded institution that did not value freedom and wanted to say that it was representing a point of view, and if you didn't have that point of view, you weren't welcome there, it could do that. But if it's going to represent itself to the world as a place that values fundamental freedoms, different points of view, then it was functioning the way the old public town square functioned in the early days of the Republic in New England. And by that time, the Supreme Court had resolved, remember, Jim, the shopping center cases? Saying that shopping centers, private businesses, couldn't exclude people who were handing out all sorts of literature that the shopping center owner didn't agree with, because the shopping center had come to occupy the role of the public square in the old days. So I'll bet a clever lawyer could confect an argument based on Vanderbilt's own self-representation against your claim that it's got a legal right to do what it did.
Except the Pruneyard case held that the shopping center could exclude those people. The California Supreme Court had held otherwise, but the U.S. Supreme Court reversed that.
Okay.
Okay, well, I don't know which way you expect me to swing at this curveball.
You're ambidextrous.
I mean,
let me-
can I just, one
Yeah.
final point, I mean, just to make it clear to everybody, this doesn't mean, you could accept this argument, the argument from the Schmidt case. You could accept, and it wouldn't mean that, now Concordia Seminary is at risk and Southern Baptist Seminary in Louisville is at risk. Because those institutions already say, we do not believe in freedom of all expression. If you're going to be a seminarian at Southern Baptist Seminary, you got to believe what the Baptist faith teaches.
Okay, doing this off the cuff, I think it's a great argument. In principle, I think that your First Amendment right as a private institution includes the right to be inconsistent and hypocritical. Right? Who is perfectly principled, okay? And I remember my reaction to the Princeton case when it came out, thinking, well, that's wrong. It's a private institution. It should get to be the way it is. But here, I think this is a nifty idea. Because as a matter of First Amendment free speech law, you have free speech rights. They are yours to sell. You can contract away your free speech rights. There's a famous case called, I think it's called SNEP, and it involves a question of whether a CIA agent, having made a contract of employment with the federal government in which he agreed not to ever disclose stuff from the CIA, could be restricted from publishing a book. And they said, his argument was, I have a First Amendment right to publish a book. And the government's argument was, yes, you do have that right. You negotiated it away for purposes of this specific government employee, okay? So here's the argument I would raise. I'm going to phone it back into headquarters, because I think it is consistent with the First Amendment. Vanderbilt's First Amendment rights include the right to have contracted away those rights. If it is true that the Vanderbilt policies, as stated, create some sort of vested contractual rights in students to open forum free speech policy, Vanderbilt may have painted itself into a corner. It can paint its way out as a matter of principle, okay? And, you know, given that boy, there's a good reason I don't teach contracts. I'm not sure this is a contract, if this is a deal, but I'll leave that to the students at Vanderbilt to take on as a class project.
Yeah, I'll be very happy if the administration and faculty of Vanderbilt University would just decide to say, look, we're just the liberal equivalent of Southern Baptist Theological Seminary in Louisville.
Question.
Okay.
Yes, is this on? This is a question about what I think is a fairly simple idea, but it appears that clear that Vanderbilt is discriminating against student organizations so that the student organizations will not discriminate against individuals. So it seems that there is a strong value of individual rights over the rights of an organization. You've touched on that tonight. But I was wondering if in the common language which would appeal to, say, a board member, what would be the basic problem with valuing individual rights and pretending you're not violating the rights of the individuals who constitute the group or the student organizations? Does that make any sense? Because it doesn't make any sense to me that the board and administration are suggesting they are not violating the rights of a protected group, religion, with their non-discrimination policy. It seems so obvious, it's hard to wrap my mind around how they can be saying they're not violating the rights of student organizations by kicking them off campus. They're clearly discriminating against religious organizations for the sake of protecting individual students who might want to be a member or a leader in an organization. So how can we make that clear in common language that the rights of the group are the same as the rights of the individual?
Well, I assume that's directed to me. How can you make it clear to, I don't know, I've always had trouble making anything clear to university administrators. Well, and actually, you know, I actually think that as a descriptive matter, that's probably what's going on here. They view it as we have a no student organization may discriminate policy. We are doing what was upheld in Christian legal society. We forbid all student groups to discriminate. And I actually think they do not recognize that, you know, it's sort of a simple-minded, wooden-headed bureaucrat's approach to dealing with problems, you know, which is a problem. How, you know, is a species of the problem. How do you get through wooden-headed skulls? You know, I think you bore hard. You know, but I think that's the problem. You know, I do not know, but I do not believe that Vanderbilt University administrators believe. I think they believe they are protecting students from discrimination and do not recognize the reality that they're acting inconsistently with their basic. I don't know, get them to come to some of these forums.
Yeah. Let me just kind of kick in.
Use mic, okay.
Let me just kick in on that. Just as in the contraception case, a line has to be drawn for the exemption. How far would the exemption go? The Obama administration says for churches, yes, but for church-run organizations, no. I think the problem here comes in a one-size-fits-all. I think that if you play the law professor game and say, well, should there be a Christian students' German club, for example, that would exclude Jewish students, that would be a problem. It would be a problem for me. I think it would be a problem for most people. Should there be other organizations? In the past, those of us of the Jewish tradition have been excluded from many organizations that we should not be excluded from. And so one can't just say it's okay to define and exclude based on religion. On the other hand, there are certain religious organizations that have a religious dimension to them where the exemption for free exercise should trump the rule of non-discrimination. And it requires some hard thinking about where that line is to be drawn. I think it's not acceptable to say there should be no line, that we should have a non-discrimination rule across the board. But I, for one, am not ready to say that any time any group wants to call itself a Christian group or a Jewish group or a Muslim group, that should give it the right to exclude other people of other faiths. I think that's too broad. So what we need to do is to think, where is the line? And that's the argument we're having on the contraception issue. How far do you want to draw that? Where do you want to draw that line? Do you want to draw it at religious institutions, or do you want to go beyond where it's religiously run institutions? And there, I think it depends a little on what the access problems are and so forth. But I think that's the honest debate. And I think that here, there are very few organizations that are religious organizations, and I'd want to go through one by one and see, is the faith part of the core mission of what's going on? And the argument is leadership. That's a narrower focus than participation. Now, I think the problem that everyone knows about is that if you have open participation and open leadership, then you have a potential for a problem. But you can have open participation with guidelines for leadership, and then you can still preserve the nature of the organization. And so I think that if you want to drill down, one needs some sense of what types of organizations have this primary religious focus that we want to protect under free exercise type principles, and how do we protect them? What's the kind of the narrow way of respecting other religious opportunities, and are there other religious opportunities? I mean, I think that becomes fair. And so if there's a Christian legal society, is there a Muslim legal society? Is there a Jewish legal society? Is there a conservative Christian and a liberal Christian? I mean, how flexible is it? And I think that those are all things that need to be done. It's too easy bureaucratically to say, we're going to have a one-size-fits-all rule of non-discrimination. But I, for one, would not be in favor of a totally laissez-faire regime that says we're not going to enforce non-discrimination rules at all. I think that we have to drill down and see where the religious values really matter and how to protect those in a reasonable way.
I agree with Professor Blumstein on that point for sure. And I think that the main thing that you're interested in avoiding by going too far to the other direction is allowing pretexts for invidious discrimination or difference exclusion that's not based on principles, but is based on something unsavory. The only point I would add to what Jim says is that I don't think there's anything peculiar about religion here. I think that the same sort of consideration should apply to other groups that are built around common beliefs or common principles. So I think that it should be okay for the Young Democrats Club to say, well, look, if you're going to be a member of this club, you can't be registered as a Republican. You have to be registered as a Democrat. And it could be the same for other areas where there's issue advocacy. Because just as you want to be on your guard a little bit about pretexts, you also need to be on your guard probably more than a little bit about creating a situation where a minority position, a group representing a minority position when it comes to the prevailing orthodoxies on campus, can just be overrun by people who don't share their convictions coming in and taking over their organization and acting publicly in its name.
My name is Richard Aberdeen, and my consistent experience in life is that liberals believe in freedom as long as they agree with the freedom. And conservatives believe in freedom as long as they agree.
Yeah.
And very few people in America really believe in freedom. I currently have both the ACLU in Nashville chapter and the Americans United for Separation of Church I call Sanity. They're angry at me because I believe conservatives should be able to talk about God in science class because I believe in freedom. So what I see here in this group is I see hypocrisy running other direction. You want to afford freedom, but you don't want to afford women the freedom of abortion. You don't want to afford gays to freedom. And to me, this is just hypocrisy from both sides.
So unless someone agrees with your position on abortion
I'm
and gay
saying-
marriage, wait, hang on, let's hold you to what you
Let
say.
me finish.
Unless somebody agrees with you, then they're a hypocrite if they say they advocate freedom. Is that right?
No, what I'm
Okay, then
saying
what is
is, if you have a certain amount of people in a society who consider themselves to be gay, or you have a certain amount of people in society who believe abortion is a human right, then your religion doesn't trump their freedom, whether you agree with it or not. And I'm not saying that you have to have an abortion or that you have to have a religion that supports gay marriage. I don't care. I don't like to see people having their freedoms stepped on. I agree.
This argument will not fly. It will not fly for this reason. The question of whether that entity developing in the womb is or is not a living member of the species Homo sapiens who bears the same rights as you or me is not a question that one resolves simply on the basis of looking it up in the Bible or in the Quran or in the Book of Mormon or any other scripture. That's a question of scientific fact. If I premise my view that, in fact, the child in the womb deserves the protection of the laws like anybody else, on that scientific fact, then in no way am I imposing my religion on anyone else.
But you
I
are
respect
if you
your
deny
right
them
to
the
disagree.
rights.
I respect your right to disagree with it.
Yeah.
I don't call you a hypocrite for taking a view that I think cannot possibly be vindicated by
But you
science.
would deny them the right to have an abortion, or you would deny
Now, why
them
would
the
I
right
do
to
that?
have a gay marriage.
why would I do
You
that?
are stepping on their rights.
No, why would I do that?
Oppose this law in California, where I'm from, by the way. And also, I witnessed Jim Crow firsthand because my grandfather had a farm in Jasper, Alabama. And when I was a kid, I saw men, women, and colored. I saw people of dark skin being pushed to the backs of the bus and have to be stand while people with light skins, kids, got to sit down.
I believe your testimony. When my father was
I
growing
see
up,
the
a
same-
cross was burned on his lawn
Okay, so-
because he was a Syrian immigrant.
Okay, and
Now,
I've seen
hang
this,
on.
I see the same thing here where you would say, well, our group doesn't, we don't like people of dark skin eating in our restaurant. That's our group. It's like a federal issue. It's not I mean, it's a federalist issue rather than a
Let me ask you a
federal issue.
scientific
See,
question.
it's the same argument.
Is a fetus a member of the species Homo sapiens or not? A human fetus?
Me personally, do I
No,
believe?
as a matter of scientific fact. Member of species Homo sapiens or not?
Well, let's put it this way.
No, let's put it yes or no.
Oh, no,
Is
let's,
it or isn't it?
let's take an authority.
Yes,
okay?
an authority.
I'm going to quote you an authority.
I want one.
According to Jesus,
No, I want more and
I see. Jesus is not an authority.
He's not
to
an
the
authority
Christians.
on
I'm
human
finished.
embryology and
If you-
developmental biology.
Jesus is
the
an
authorities
authority,
are named
sir.
Moore and Purcell,
I'm sorry for
O'Reilly and Mueller, Larson, Carlson. Those are the authorities who know modern science.
Jesus said a man had to be born by water. That's physical birth, not conception. So if you want to go by some
Oh, for
other
heaven's
authority,
Sir, would you yield the microphone to some of the other people who want to ask questions?
I understand what birth by water.
How about embryology? Let's talk. You're talking about religion, and you said you didn't want to impose your
Christians who
religion.
don't
How
believe
about
Jesus
science?
is an authority. I feel
Sir?
sorry for you.
Sir, would you yield the microphone? Thank you.
May I say something? I want to take some clarifying good out of that highly interesting exchange. One can believe in freedom of speech and association and decry the efforts of right and left to censor each other. As I do, I believe in freedom to that extent. Okay? A consequence of that is that people get to make, in public discourse, the arguments they think are right. It does not mean that when that argument loses, winners are hypocrites because their view prevailed. Their view prevailed presumably because they were able to persuade a majority of their citizens of the correctness of their reasoning, and the principle of our democracy is that the persuading of the public domain to enact certain policies should be given effect without prejudice to the ability of the losers to come back and argue second time, okay? There are some things, I think, that are right and that are wrong, and I will argue for those in public discourse. I think even that the gentleman who raised the question agrees that there are some things that are wrong. Slavery is wrong. Racial discrimination is wrong. Professor George and I, and many of the others, think that killing an unborn human life is wrong. The fact of holding views about right or wrong is not hypocritical. It is an implementation of the right to disagree.
Let me just say one more word. I don't really want to turn this into a discussion about abortion. Abortion is a very polarizing issue, and it's a very difficult issue, and I certainly have no special wisdom on it. But I think that the questioner, when he was focusing on one's freedom, you know, I may have the right to shadow box, but that right ends when it hits Professor Paulsen's nose. And so the question becomes, at what point are you intruding on other claims of right or entitlement? And that's where I think Professor George was headed, is what, and he and I would disagree on whether it's a purely factual question or whether it has a normative dimension as well. But once you reach the conclusion, whether it's purely factual or a mixed question of fact and norms, if you conclude that the law should protect the fetus in the same way that it protects a postpartum birth, then the argument of the questioner that this is hypocritical, that you're not protecting that freedom. No, you're just saying that freedom is constrained by another claim of entitlement, the protection of the fetus. And so I think that's what the debate about is. We don't have unfettered freedoms. We have freedoms that are constrained by other claims of entitlement. And the issue in abortion, is the hard issue, is how do we balance the claim of entitlement to a woman to control her own reproduction and the claim of some form of legal protection to a fetus, and at what stage and to what degree? I mean, I think that's the hard question, and you know, I don't claim any special answer to that. I'm just going to frame. Lawyers are good at framing the issue. I'm not going to answer the question.
And then ducking the issue.
Yeah, and then ducking it. But I think it's not. I mean, I just want to urge the questioner to rethink his position, that it's not a question purely of one's freedom. There are mixed questions on things like abortion that raise the issue of what is the equivalent of someone else's nose that I can't punch.
This question is specifically for Professor George. I was looking at, for example, in the Federalist Number 10, Madison brings up much the same idea you talked about, in that in what he called popular government, factions arise and they have this sort of groupthink tendencies, and it creates problems in the government. That being said, he thought that our Constitution was unique and that it worked against these problems. And although he didn't say exactly how, he seemed to indicate that through the federal structure of government, that no one faction would be able to present its will without reaching across the aisle, metaphorically, and that if, you know, one group agreed with one policy, different interests would have to work together, and you know, two people might be in agreement on one issue and work together, and then the very next day disagree on another issue and be working against each other, and in doing so would have mutual respect for each other. But you know, looking to the very beginning of our country with the Federalists versus the Jeffersonians, it seems like this idea broke down and has not improved since then. I mean, is this an area where the American experiment failed? Is that a too pessimistic approach? And is there any way, even governmentally, we can work towards that goal that our Constitution currently isn't doing?
Well, that's a terrific question, and your reading of Federalist 10, I think, is correct. I just add, in addition to federalism, Madison and his colleagues thought that the separation of powers, which was not something that was popular, of course, in the European states, but that the separation of powers would also tend to militate against the problems that were created by faction, because people would have to work together in different kinds of alliances on different issues. I think it is too pessimistic. I think that reading is too pessimistic. It's colored in part by the polarization that we're experiencing in our own time. We're a very highly polarized and stratified society, and with a polarization along partisan lines that's new in our lifetimes. It's not new in history, but for us it's relatively new. I mean, we all, well, not everybody, because some of you are quite young, but most of us in the room lived at a time when there were lots of conservative Democrats and more than a few liberal Republicans. Now you've got a situation where the Republican Party is a solidly conservative party and the Democratic Party is a solidly liberal party, and the few lonely dissenters within the parties really are lonely. So it gives this impression of breaking down. But I still think that the system that the founders put into place is doing a good job for us. There's no way that any human system can function perfectly and can function against the vices, including the vices that give rise to faction, flawlessly and perfectly. It just can't happen. And for reasons that Madison himself understood very well, because he was tutored at Princeton by that. I was waiting for a chance to get that in, Carol. By that great Presbyterian John Witherspoon, who was the signer of the Declaration of Independence, but above all was a stern Presbyterian minister of strong Calvinist conviction. And they knew something about one thing. They really knew one thing well, and that is the fallenness of man, original sin. And you just can't come up with a mechanism that's going to do away with that or do away with its consequences. But even today, in this situation of polarization, it is possible for people to work across the lines of division. And I can just tell you from my own experience, and I'll bet my fellow professors up here, all of whom are active outside the academy in civic life, have their own experiences. But just my own small number, working across partisan and ideological lines in combating the trafficking of women and children into sexual slavery. The Catholic Church is working with the Reformed Jewish tradition. Democrats are working with Republicans, conservatives, with feminists, and so forth. That's an area. Human rights in Korea and China. That's a left-right alliance, if you look at it. In some dimensions, this is an interesting set of bedfellows that gets made by this issue. The fight against obscenity and child pornography and so forth, that sometimes brings socially conservative Christians and Jews together, and Muslims now, actually, in this fight, together with feminists against the more libertarian people on the right and some of the more permissive type people on the left. So, and I could probably think, if I gave it a couple more minutes thought, I could think of more just that I myself am involved with, and I'm sure the professors could think of cases that they're involved with too. And I think those are important. Those are important not only on the substance, because they are very important, worthy causes that we ought to be pursuing together. They're also important because it's hard to demonize a guy, no matter how much you disagree with him about abortion or marriage, when you're working with him against human trafficking or in support of human rights in Korea and China.
What a wonderful panel, and a blessing to Nashville that you gentlemen are here. My name is Austin Davis. My direct bloodkin uncle is Patrick Henry. And so when I hear, is it Professor George? When I hear your passion tonight, I was watching the Vandy game and came here at the last second, but to hear your passion about tyranny, freedom of speech, the ability to dissent, to listen, those are moving things and much needed in our society, and stir my heart just hearing it. Freedom is very hard won, and tyranny is really difficult to roll back once it's got its position. I personally have experienced it here in Nashville. Even tonight, and my uncle spoke on the 4th of July, his speech, which he said, "Give me liberty or give me death." On the night of July 2nd in 2008, I had Metro detectives come to my home basically invaded my private home and threatened me and my family, and I remained under threat of arrest tonight in perpetuity for the rest of my life in this city. Speech is either free or it isn't free. And so I just say that because I'm in a, John, who was up here a minute ago, other people that are in here that I know, we're standing on property. If the powers that be decide they want to do things to you, remove you from it, take your freedom away, they can do that. So I would, having experienced it myself, I would exhort all of you to dig in and do everything you can to speak while you can.
I'd like to take us back to the Vanderbilt issue. Important issue to me as a graduate of Vanderbilt and a lifelong supporter of Vanderbilt. This issue is creating crisis of conscience for me. My understanding is the policy has now been issued in written form. Is it correct that it exempts the Greeks, fraternities and sororities? Well, when I communicated with David Williams, who I believe is the chief counsel of Vanderbilt, he said that Vanderbilt had had a non-discriminatory policy since 1990. And he referred me to a website which had your standard hiring policy on there, that Vanderbilt would not discriminate in hiring employees based on race, sex, and the other criteria. Mr. Williams told me that that has always been enforced, and now they were going to enforce it on organizations on campus. Well, when I looked at that, he's right. I mean, if you're an organization on campus and they're saying you can't discriminate based on religion, then in leadership, which is what his position was, then he's right. Those are not legitimate organizations on campus. But I don't understand, I mean, the basis of the Greeks are to discriminate first on sex and second on whether I like you or not. How does he exempt them from that policy that he referred me to, which says they won't discriminate based on sex, religion, sexual orientation, whatever the long list is that we all know, that we all see when we're instituting hiring policies? How does he exempt them?
I don't want to answer the part about how he gets to his exemption, but I can tell you that Vanderbilt University, they maintain that they never changed their policy. But if you go and look, I mean, we have copies of the policy as of December 2010 and then April 2011, and they removed a sentence that protected religious organizations, that exempted them from the policy, that respected their rights of religious freedom. And a couple of weeks ago, they removed the faculty's rights of religious expression. And so the university maintains that it hasn't changed its policy, but we have documentation that it has changed its policy, and it removed language that protected religious groups.
Well, okay, and of course that's different than what he told me.
Yes, it is.
I mean, you know, he was probably too busy in his athletic directorship to really look at the legal basis. But so how do they exempt? I mean, what does the policy say about fraternities and sororities?
Well, what he's saying is that Title IX of the Civil Rights Act, 1964 Civil Rights Act, that it allows them to make the exemption for Greek organizations. And it is totally inconsistent with the argument that Vanderbilt is trying to end discrimination on campus, that they're against discrimination, that they have an all-comers policy. If they had a true all-comers policy, then they would have to apply it across the board to all the student organizations. They wouldn't be able to exempt the Greeks.
But what about the case that he uses, the one I think you were talking about in California? Did that university have fraternities and sororities, and were they exempted?
It was a law school. I don't believe they had fraternities or sororities.
So it was only a law school. Okay, I've taken enough time.
It was Hastings Law School, and I don't believe it was not an undergraduate, it was a law school. And there's a factual question whether Hastings actually had an all-comers policy or not, but
Well, I mean, the issue is, as you've pointed out,
Stipulated.
Vanderbilt does not have to enforce it that way. I mean, they're free to do whatever they want to do.
yeah.
They've just chosen to do this.
I don't know what David's position is now. He's a very good and careful lawyer, and I don't know what the past position is, but there was a sentence that was deleted from the handbook, and it was deleted in response to the ending of the don't ask, don't tell policy. It was a sentence that had two dimensions to it. One was that every university, Vanderbilt, Harvard, had a position that allowed military to come on campus even though the military discriminated based on sexual orientation and based on sex. Who could be in combat, who could not be, and they were not hiring gay lawyers, for example, in their JAG Corps. That ended, that discrimination in the military ended in December of 2010 or whenever, in that lame duck session of the Congress. And so the universities had caved on that because they didn't want to lose all the funding for their medical schools under the so-called Solomon Amendment. But there were two aspects of that one sentence. The one sentence focused upon the government. The second sentence said, the sentence says, notwithstanding this general policy, it doesn't apply to off-campus groups such as military, and it does not impede on the right of conscience of people. Those were in the same sentence. And so when don't ask, don't tell went down, that entire sentence came out. And only the part relating to JAG had to come out. The conscience provision did not have to come out. My own theory is, and I can't prove this, is that somebody was a bad editor, that they just took the whole sentence out, and now it's become a matter of principle. And I'm just guessing that that's what happened.
Yeah, that's the removal from the faculty handbook that probably 90% of the Vanderbilt faculty are not even aware that they've lost an important right. But the student handbook, the university did change the policy, so it's not the same policy that was in place in 1990, and we have documentation to prove that. But our documentation has not stopped the university from maintaining that it has never changed its policy towards religious organizations.
Let me just make three quick points. It is clear that the policy with respect to student organizations has changed, and certainly the practice has changed, so that's new. Secondly, I still think Vanderbilt can have whatever policy it wishes, and it can be inconsistent and do things against its stated policy, subject to Robbie's challenge to that. But third, if what they're relying on, if their moral justification is that we require all student organizations to take everybody, right? That's their bright line argument. Call them on it. Right? Say, okay, first 30 dudes in the door, male or female, we don't care what they look like, who their daddy is, or anything like that. You have to accept. I think if Vanderbilt's feet were held to the fire on that, on fraternities, sororities, then I'll, whoa, right? Then I think you would see some change, and and a light might actually go on through the wooden heads that.
Make an additional
Go
point, not about the specific policy, but more broadly on the importance of this. I think a lot of emphasis by critics of the new policy has been on individual rights and on religious freedom, and that's true, and that's good, and that's important, and I think people should continue to make that argument. But I want to say a word on behalf of the integrity of liberal arts education. Even laying aside the religious freedom issues and so forth, no serious Christian, other faiths may also be like this, but no serious Christian group, whether it's Protestant or Catholic, is going to be able to accept the idea that you could have people in leadership and speaking for the group and representing the group to the community and to the world who do not believe in the teachings of of the faith. So what it means is they're not going to be able to get recognized campus status. They're not going to be able to have the advantages and put on the programs and so forth being on campus. Now, that's not just a violation of their rights. That's an impoverishment of the dialogue that is so essential, the discussion, the vigorous debate that is so essential to the life. It's like oxygen, you know, it's so essential to the life of the university. In a university like Vanderbilt that really does, or Princeton, proclaim itself to be an open forum for all sorts of ideas, really does need to have the Christian point of view, and the Muslim point, and the Jewish point of view, and the secularist or the atheist point of view on campus, represented with people free to weigh in, where their organizations have integrity, they can't be taken over, they can't be misrepresented. That's just so essential to the mission of the university itself, that partisans of liberal arts education, even if they're not themselves believers, and even if they don't care all that much about the constitutional question, should be in the forefront of this fight.
I'd like to follow up on that last question, and to a point that Professor Paulsen made, and that is, you said call them on it. I was at a meeting this morning and was made aware of a student, undergraduate student, who is gay, and he believes that he was discriminated against by not being accepted in a fraternity. And the story that I was told was that the university was made aware of this and they turned their back to it. Said they didn't want to deal with that. So I know I'm a graduate of Vanderbilt, graduated in 1981. I was discriminated against when I went through Rush. I did not get offered an invitation to join the fraternity that I wanted to join. And it was a tough experience. It was one of the really formative experiences of my freshman college year. Now, subsequently, I ended up joining that fraternity later. But under this all-comers policy, I was discriminated against my freshman year. I don't think I have, I'm not a lawyer, but I don't think I can go back that many years and file a claim. But to your point, Professor Paulsen, there's students in this room. I know that we all in this room know students who have been discriminated against by the Greek system here at Vanderbilt. I think it's a wonderful system, but I think you've pointed out the hypocrisy. And if we need to call our university, I would just challenge you students to find a student who is willing to say, I have been discriminated against. Because let's remember, this whole issue has been started by one student, one case that has not yet been resolved by this university. It is still under review. And we are all here tonight because of that one student's claim. So I would ask that everybody in this room that's a student, ask your fellow students, who will it be? Who will go to the Vanderbilt Hustler? I saw Kyle Blaine here earlier. Who will go to Kyle and ask him to write an article in the Vanderbilt Hustler that I have been discriminated against by Greek life? And let's see if this university will pay any attention to that, because I guarantee you the Greek alumni, which I'm also a part of, will not be very happy with this university if this university tries to run all of Greek life off of this campus. But thank you for bringing up that point. And I just challenge you students, go find that person. And my question was going to be, how can we help resolve this issue? But I suspect that you've brought to us what may be an important part of that if we can find that student.
Well, just quickly, because you guys have endured 2.25 hours, 2.25 hours of law professor blather, and a thank you for that. You know, my view is ultimately Vanderbilt has the right, legal right, to pursue the policy it does, whatever policies it freely chooses. But, you know, similarly, Vanderbilt alums, students have, of course, the right to persuade and pressure Vanderbilt to do what they think the right thing is. I think ultimately it comes down to reasoned persuasion of people who may be just a little bit dug in for institutional reasons. You know, and displacing that dug-inness. People are dogged once they've gripped something, and just work on prying that loose by good persuasion.
You know, I do think, as I said earlier, that it's very important to try to understand the other guy's argument on any issue, including this issue. So I think it is very important to try to understand why the people who are responsible for this have put this policy into place. But, and I have a question, this is a sincere question, I don't mean that this is not a joke, it's a sincere question. I'd like to know from my fellow panelists or from anybody in the audience what the answer to it is. What reason would a student have, other than to undermine the group he's purporting to join or lead, he's trying to join or lead, what reason would he have for joining the group and offering to be a leader in the group, seeking to be a leader in the group, if he didn't believe in what the group stands for? Is there a non-bad reason? If we understood that, maybe we could understand the policy.
The provost speaks in terms of inspirational leadership. He wants to have a university where there's inspired leadership, and he believes that if a person comes from a different background with a different set of beliefs, that will somehow benefit the organization they're trying to join.
But let's say my organization is the Roman Catholic student group, okay? Now, what motive, what good motive would, let's say, an atheist student, didn't believe any of this Catholic stuff, didn't believe the church's teaching that there's a God, that Jesus Christ is the Son of God, that the Eucharist is the body and blood of Christ, didn't believe it, what good reason could that person have for wanting to join? Now, I can see if it was a bad reason, he wanted to join the group to undermine it. I get that. But what's the good reason?
I'll offer an answer. I think the reason is that there are many, as you have said, in society who are Catholic. Let's take them since you brought them up. There are many that don't believe what the Catholic Church is teaching is the proper teaching for the church. And so they would want to be not only a member, but a leader of the organization here on campus, so that they, in their new position of leadership, can use that to start teaching against whatever that may be. Maybe it's contraception. Maybe it's gay marriage. Maybe it's take your pick. But it offers them the opportunity to, in essence, begin to change the very beliefs of that organization by getting into a leadership position.
But that looked to me like the bad reason. So I just want to know what
But they view that as a good reason. That's the issue. They view that as a good reason. And the other side of that, to me, that I want to throw in there is that if you don't have that protection, as the Vanderbilt Catholics have announced, their church will no longer sponsor a Catholic organization at Vanderbilt because they no longer have the ability to protect what their message will be within their church. So whether or not there's any good or bad motive by anybody, just the fact that the organization outside of Vanderbilt is not going to spend the money, the time, and the energy to provide a group, you know, without the protection of the policy, they're gone.
Well, I can certainly understand why the Catholics are taking that position. I mean, all the effort they had to put into fighting Arianism and Monophysitism, and so they've been through this before.
Okay, with that, we're going to end the panel. we're gonna end the panel. Christine Powell, is she still here? Okay. Okay. While she's collecting the cards for the raffle, I guess we can continue our discussion, but I suspect the whole policy is about secularizing religion, that the goal of the university is to make it like a social group, and that it's really motivated by people who have no appreciation of what it means to be a person of faith and to try to live by those values.
Professor, could I ask one question? Tom Smith, I was a Vanderbilt graduate too. How serious a problem is it to opt out of this? In other words, what are the consequences? As I heard it, school just loses some of their money and they simply walk out from under. I'm for changing the policy of Vanderbilt, but assuming it's in a bureaucratic hold, what are another option, another test case might be a mass exodus of some of the key groups off campus, but still serving the Vanderbilt students. Is that an option? The question is that an option?
Well, the groups that leave campus, the students will still be members of the student body. They will be paying student fees to subsidize other people's organizations. And what it means is that they will not be able to recruit members at the student fairs, and they will not be able to reserve rooms or compete for student fees. And these are fees that they're paying as well. And so they're subsidizing everyone else's organization.
But what's that cost? And if the principle's important enough, why wouldn't they just walk out?
Will.
Can I speak briefly? I arrived a little early today so I could speak at noon to the Christian Legal Society. The Christian Legal Society was meeting in this room in order. I found the room because there's this sort of scrolling reader board that announces where and when. Christian Legal Society was meeting here and at noon, and I found the event because it was listed on one of these electronic bulletin boards, and they met in a classroom. As I understand it, that can't happen next year. I cannot be invited as a speaker and have that publicized and known within the traditional law school media. Now, to their great good credit, the Christian Legal Society chapter here, and I know that the other student religious groups have done this or will be doing that, said we would rather suffer these detriments, which will be hurtful to the organization, than to accede in principle to the idea that we can be coerced or pressured into abandoning a statement of faith ideals, right? As oppressions go, this isn't exactly being fed to the lions. But it does come with a cost in community life. It comes with a cost in terms of outreach and fellowship, and as Robbie George pointed out, in terms of the academic program and intellectual and cultural life of what should be a great university.
Carol, make sure my friend with the mustache wins my book.
Carol, can I say one last thing?
Right.
Professor Paulsen is one of the authors and signatories to the letter that many may or may not know was sent to the chancellor on this issue back in October. And for those of you that are interested in following this, there's a website now that has that letter, lots of information, town hall video. It's called VanderbiltReligiousFreedom.com. And if you do want to continue following this, go to that website. Many videos of Carol on her Fox News broadcasts and all those things are on that website.
And you...
VanderbiltReligiousFreedom.com.
And you can go to that website, sign a petition, and also make a financial contribution, because to keep this issue in the forefront of the news, there are people that are engaged in a campaign, and everything. There's a cost to everything we do, and so you can make a financial contribution. You can sign the petition, and you can urge other people to go there. And we also have links to documents. You can also go to the National Christian Legal Society website, and there are many documents there that you can review as well. So we do urge people to get involved and realize that what happens here at Vanderbilt will also affect other universities and colleges across the nation. If this policy stands, then you can expect other private institutions to follow suit. So thank you for coming, and I'll let Christine announce the winner of the 2 books.
All right. So, what